Good afternoon, everyone. Thank you so much for joining us this afternoon for our webinar on the small cells and the legal rights and practical approaches for Connecticut municipalities. I am Donna Hamzy, and I am the Advocacy Manager for the Connecticut Conference of Municipalities. My partner in today's webinar is, as you all know, Attorney Bert Cohen from the law firm of Murtha Kalina. I'm going to take a moment just to do some few housekeeping items for all callers who are currently listening in listen-only mode. If you have any questions, you can certainly type them in during the course of the presentation into the message box or the question box, and we can answer all of your questions towards the end of the presentation. This webinar will be recorded, so it will be available for folks later and after the presentation, so we can certainly send those to you with the presentation slides. And I will, without further ado, we're going to turn it over to Bert to start the webinar. Thank you.
Thank you, Donna, and welcome all. Let's start with what are small cells? We're just going to pull up that slide.
One little technical difficulty here. We'll just moving into the next slide. We'll give us and bear with us a moment.
Keep talking. So, anyway, what we're going to talk about is the small cells are basically they're self-contained wireless communication facilities. Each one supports a single carrier, and the main carriers, as we all know, are Verizon Wireless, AT&T, which operates under its singular name, Sprint, and T-Mobile. They operate on one or two frequency bands, and they transmit low power. They can have embedded or external antennas, but as we've seen in Connecticut, at least with respect to Verizon Wireless, there is a strong preference for external antennas, ostensibly because they offer greater flexibility in reaching a target area, and they probably are easier to design to install because it's by a separate, it's a standard design. So, Don, I want to take over something about discuss the municipal concerns that we have.
So as you know, you all are on the phone because there were municipal concerns back when mobility came into town and blanketed you all with letters saying that they were coming in and taking over, so to speak. So, of course, a lot of those concerns brought up some safety issues and also just some effects on property value issues. So CCM got involved, and just quickly to get into the aesthetics, there are likely 1,000 small cells in Connecticut over the next 3 to 5 years, which means this proliferation is going to explode as this technology gets more and more popular, many of which will require the installation of taller utility poles. So, of course, in maintaining the integrity of these poles, they will need to be switched out in order to sustain the added weight of the small cells. And then, in addition to that, we wanted to make sure that you all are keeping up with the personal property tax rolls for these small cell facilities as they are being installed in your town.
Okay, thank you. I'm going to do a little bit on the regulation scheme for small cells. Much to the detriment of municipal interests, the Federal Communications Commission has asserted preemptive authority over a lot of the issues regarding the operation and the siting of wireless communications facilities, and that includes small cells. So much of what occurs here in Connecticut and elsewhere is dictated or limited by the rules and regulations of the FCC. State regulation of wireless communications carriers is essentially preempted by the FCC, which means that all quality standards, service quality standards, are basically out of and rates are out of the hands of the of state and local regulators. Municipal regulation is limited to we put it on the slide as zoning, but we really mean the siting of these particular facilities, except in Connecticut. Connecticut, I believe, is the only state where the siting of wireless communication facilities rests in the state of Connecticut, and as we'll get into a little bit later, some of that rests with the Public Utilities Regulatory Authority, and others rest with the Connecticut Siting Council. So we also wanted to give you a little photographic depictions of some of the small cells. Again, these are things that are off of the internet, so hopefully we won't be subjected to copyright infringement. But if you look at the upper right corner, you'll see there's two prongs. Or upper left corner, I should say. There's two of these small cell facilities. There's an extension off of the pole. The upper middle is very interesting. That shows a billboard, and the wireless, the small cell facility is located behind the billboards. So aesthetically, one doesn't see it. Now, you don't see all that many billboards in Connecticut except on the highways, but it's worth noting. On the far right, you'll see it's basically located on a street lamp pole towards the top. The other one that I like is the one that's in the middle. Again, it's street lamp situation, and you have the facility is disguised as a street lamp. And then next slide is a depiction of what Verizon typically uses in Connecticut, which is the extended utility pole with the small cell facility on the top of the pole. What's not shown here is that there is another pole that is usually, there's an electric wire that is usually strung to another pole, and that's where the small cell facility gets its power source. And then, just for a little humor, that is not a small cell. So we'll go to the next slide. Okay, we did, thanks to the efforts of CCM and a few municipalities, the small cell siting rules have evolved. But let's just take a look at where they were prior to June of this year. PURA asserted that it has jurisdiction over all of the small cell facilities that would be placed on utility poles. And the legal theory for that is that, according to PURA, is that they have exclusive jurisdiction over utility poles that are used for, an electric distribution system. So those would be typically utility poles used by Eversource, used by Eversource and UI. There are also poles owned by Frontier communications down in Greenwich by Verizon's telephone company. But in any event, the statutes don't cover anything that has to do with small cell facilities, and so the plain meaning of the statute didn't necessarily support Pura's assertion of jurisdiction, but nevertheless, that was their theory. There was no prior consultation with what we refer to as the host municipality, that is, the municipality in which the subject pole is located. Municipal officials were not notified of a small cell facility application filed with Pura unless the pole was located on town property, and that is town-owned property. The only contact person that would be available would be the attorney for the wireless provider. The municipality could be a party in a Pura proceeding if the pole was located on town property, but the municipality would have to petition to, the legal term is called intervene, for all other proceedings, all other applications that were not involved towers, pole towers that were not on town property. Now, Siting Council, by contrast, has jurisdiction for most other wireless communications facilities. And so, give you an example, on the small cell side, if a small cell facility were to be located on the top of a building or on a someplace off of the public right-of-way, then that application would go to the Connecticut Siting Council. We'll talk a little about the West Haven case, a slide or two down the road. But in that particular case, there was a situation where a pole that was being challenged by the city of West Haven and by adjacent property owners in that docket was located obviously on the public right-of-way, but down the road about a half a mile was a wireless a small cell facility that had been put on top of a commercial building, and that small cell facility on top of the commercial building was approved by the Connecticut Siting Council. So as you can see, it gets a little bit complicated in terms of the overall regulatory scheme as to which entity has jurisdiction. And my research shows that Connecticut is the only jurisdiction, the only state that has this type of bifurcation of siting authority. And then finally, although there haven't been too many of these instances, it has been undisputed that if the proposal is to site the small cell facility on a municipal-owned street lamp, that the municipality would solely have the authority to approve that. That would not go to the state. So that was the state of affairs several months ago. Now, how did we get more siting authority? Well, with a lot of help from a few municipalities and the direction and strategic support of financial support of the Connecticut Conference of Municipalities, we did make some progress, but we had to go through basically three significant regulatory proceedings. One we call the Greenwich docket, which was 1606-38. And for those who are really interested in how these docket numbers get assigned. The first number is the year. The second number is the month in which the docket is initiated, and then the final number is the order in which the dockets are established during the course of any given month. So the Greenwich docket was a declaratory ruling proceeding in which the town of Greenwich and the city of Danbury separately had filed basically requests from the Public Utility Regulatory Authority to establish rules. What can towns do, and do we have jurisdiction? Do you have jurisdiction? That docket was highly contested. CCM played an active role in that docket. And at the end of the day, PURA ruled that it had exclusive jurisdiction over small cell proceedings and municipalities unless they were property owners that were constituted adjacent property owners. Municipalities had absolutely no legal rights. So that was the Greenwich docket. The West Haven docket, which was going on simultaneously, was funded primarily. It was funded by the city of West Haven, and I represented the city in that docket, CCM, and the Greenwich docket. The West Haven docket is important because it was the only proceeding in which the PURA issued a proposed final decision denying Verizon its application. Again, there was a lot of support from the municipality, but there was a lot of residential activism that was involved in that docket, along in that activism and the city. They were able to obtain some political support from very vocal state legislators. So, but in the West Haven docket, there were two key factors. Number one was that the utility pole that was proposed for the small cell siting was very close, extremely close to the backyard of a residence, and that a particular resident had a small child, and the couple did a very nice job of introducing photographs of their child into the record, showing that the proximity of her play area to that pole, in the event that pole ever fell down, was just too close for comfort, literally and figuratively. The second issue in that docket that was very significant was the fact that there had been it was on a curved road and or curve in the road, and so there had been a pattern of automobile accidents in that area, including accidents that had involved that particular pole, and that was all introduced into the record. So that the unfortunate part of that docket was that Verizon withdrew its application, did not go to final decision, and challenged the adverse decision on appeal in court. So again, it's not a final decision, but and it really has limited legal precedent, but it does show you at least one way to challenge or establish a record to challenge the the Verizon applications. The other reason it's significant is because a lot of what happened in the West Haven docket, the legislators who were actively involved in that particular proceeding, were very interested in instrumental in proposing legislation, which we'll get to in a few minutes. So let's go back. Now we'll go back to some of the litigation. While all this was going on, the West Haven docket, CCM funded, it was basically the primary plaintiff in the appeal of the Greenwich docket on the legal, that challenged the purist legal reasoning in terms of how it would have jurisdiction over small cell siting in public rights-of-way as opposed to municipalities, notwithstanding the fact that there's a statute that gave municipalities rights to citing jurisdiction, rather, over things that were not subject to pure jurisdiction. Keep in mind, if you going back a few slides, if you remember, I said that there was no jurisdiction. The FCC had preempted jurisdiction over wireless communications facilities and carriers. So purists stretched a little bit, but in any event, that case never went to final decision because we did start to move to the legislative arena. Don, do you want to pick up on tell them a little about the legislative process?
Sure. So over the course of this legislative session, Senator Schlossberg from West Haven, as Bert mentioned, their delegation had a lot of a part to play in a lot of the pressures that PURA felt during the course of the legislative session. And to her credit, Senator Schlossberg put forward a bill, Senate Bill 536, which would have required that there be a statewide plan for the siting of these small cell facilities, and also would have proposed a moratorium until that plan was put in place for any further installation of these small cells. So throughout the course of the legislative session, we did get some pushback from PURA because they didn't feel as though it was the place of the legislature to put forward this type of plan and that their resources were limited in doing that plan themselves. But it did also add some pressure to them in the dockets that Bert just mentioned that were ongoing during the course of the legislative session. The bill was amended to remove the moratorium, and that was just because it was found that it wasn't, that we were not allowed to place this type of moratorium because of the federal preemption. And then it was further amended to move all of the jurisdiction from PURA to the Siting Council. And as we will get into it sort of later, that was really because we felt that through the Siting Council process, there is more oversight and review and opportunities for municipalities to have real engagement in the decision of these small cell sightings within the Siting Council. Not to mention that those providers would have to pay a fee to the Siting Council, whereas they do not have to pay any fee to submit applications to the PURA. And if any of you are on these emails, you know that there are hundreds of these applications being filed all the time, and so hundreds of these applications are being filed at no cost to these providers. In response to the PURA draft decision 170249, which would have provided, it further amended, it was response to PURA's decision that would have provided municipalities with no further input to the process. So we we felt the pressure from PURA. They were not being cooperative with us, and so we really did have to the credit of Senator Schlossberg, put some pressure on eliminating them from the equation. But they certainly came to the table after those threats, so to speak, were made within the legislature.
So I'll talk a little bit about the final decision in 170249, but you have to appreciate that thanks to the pending appeal, the vigorous opposition to the proposed small cell application on Ocean Avenue in West Haven, and the legislative interest in that particular docket, and the proposed moratorium, the PURA got a clear message from the Energy and Technology Committee of the General Assembly that it needed to do something with respect to the with respect to the small cell process to placate the legislative pressure. So with that, they opened the docket, and we apologize. We're running into a few technical issues in terms of the. So in any event, PURA started this docket in February after the Energy and Technology Committee hearing. Okay. Yep.
I think we're good now.
I think we're good now. So they started this docket to basically address some of the concerns that the legislators were hearing during that during the session. And again, CCM orchestrated a lot of municipal testimony about the problems that we all were having with PURA and the wireless carriers. There was I don't want to leave anybody out, but the city of Danbury testified, the city of West Haven, the town of Guilford, and I believe there might have been a few others. But the pressure was fairly significant. So PURA responded by doing this docket. And Don and I participated in that proceeding, again, on behalf of CCM. And, you got to remember, we were challenging the underlying legal authority of PURA at the same time to regulate and cite small cell facilities in the public rights-of-way. So we get a proposed final decision, which Don and I were very excited when it got issued. And then, much to our surprise, we saw that it had absolutely nothing for municipalities. So, you go back to the on the previous slide, but we were talking about how the bill was amended to strip PURA of all jurisdiction. Somehow that got slipped into the bill, Don. I have no idea how that happened. But
no.
That got slipped into the bill, and all of a sudden we get a revised final decision that basically addressed many of the municipal concerns. So let's go through them, because that final decision now sets the ground rules for what you are all seeing in terms of small cell applications and how the wireless carriers are proceeding, and how the PURA is reviewing these applications. All right. So now municipalities, which before got absolutely no notice, unless they were the subject property owner, now municipalities get at least 30 days notice prior to the filing of an application. There is also supposed to be a request in that for consultation. And at the same time, the municipal residents who are the adjacent property owners also receive the notice. Unfortunately, although we tried to get that in, there are no specific rules regarding the contents of the notice. But again, getting the 30-day notification provides each municipality in the state of Connecticut the opportunity to discuss this with the wireless carrier before any formal legal proceedings, and then if an acceptable accommodation cannot be reached, the municipality then has rights to participate in the regulatory process. So, talk about the regulatory process a little bit. If the abutting property owners or the municipality do not object, then the proceeding is put on a fast track, and that is for the lawyers who are on the call, it's treated like a motion in docket number 170249, which is the pure formalization of small cell processes proceeding. And so I know Don and I are both on the service list of that, so we get now probably like 10 emails a day from Pure about these motions that are supposedly where Verizon is claiming there was no objection. I should also say that it is assumed by Verizon that, or any of the wireless carriers going forward, if there is no request for consultation or no communication, that silence implies consent. So, if it, in that particular proceeding, the host municipality gets what's Pure calls participant status, which means you can submit comments, but there is no hearing. And we're going to give you a sample application in a few minutes. And in that case, we'll tell you how the host municipality exercised its right for participant status. If, however, the adjacent property owners object, or the municipality objects, or both, there will be a more formal regulatory proceeding. If the property owner objects, the host municipality is automatically designated as an intervener, which has rights to participate fully in the hearing. If the municipality is the adjoining property owner, it will be designated as a full legal party under state law that gives it all the rights of a party in a regulatory proceeding, assuming that the municipality objects. And if there is an objection, absent a waiver or a settlement, a hearing is required by law. Other limitations that are placed on the scope of the proceeding, the wireless provider, again, they are required to inform the municipality and the adjoining property owners that A, the PURA has no jurisdiction over the health effects associated with the RF emissions, this is a time for my editorial comment, is that the RF emissions standards were originally established for the cell industry in the mid-'80s, and there have been very few changes to that. There are, you can go on the internet and do a little Googling, and you'll find that there's all sorts of claims that are made in other countries about people who do experience adverse health effects from being near wireless communications facilities. But in this country, the FCC has preempted all state and local jurisdiction over RF emissions, radio frequency emissions. And Pura position is that it has no statutory authority to address the effects of small cells on existing property values and aesthetics. So, again, this is their position. Obviously, it can be, the aesthetics can be addressed to some extent, but the whole thing on existing property values, Pura will not want to hear anything on that issue. We're going to do a little bit on small cell applications, so I'm going to keep talking, Donna, okay? Small cell applications, we encourage you, we strongly encourage you, since we fought for the right for your ability to review those before the applications get filed. Check out the proximity to residential dwellings. We advise that you look at whether the pole is proposed to be increased, and most of the poles are being replaced with height increases. The FCC proposes a 10% rule, which means if the height increase is going to be no more than 10%, then it shouldn't be that a height increase should not be considered. But prior to the 1702-49 decision, Verizon was putting work orders into the owners of the poles to replace them, and the replacement in many cases was occurring well before any application was ruled on by Pura. And in some cases, the poles were replaced during the 30-day notification period. So property owners were receiving letters from from the Verizon Wireless asking whether they consented or not. And while they were looking at the application and figuring out what to do, they saw the poles that were proposed to be increased being replaced before their eyes. So it didn't send a very good message that there was a fair proceeding here. So we encourage all municipalities to make sure that the poles are not replaced prior to a Pura final decision. And then the other thing that I think is worth discussing with the carriers is the relationship to where they're going to site other small cell facilities in the future. I think it's important to get the landscape in terms of where those all those small cells are going to be located. All right, we're going to go quickly through a recent Verizon Wireless application, and so this is a standard notification letter. This involves the town of Cheshire, and you'll see at the bottom there's some boilerplate there. A lot of this stuff is just a combination of legal jargon and marketing, but they do state in there at the last paragraph, bottom of that page, that Selco, which is the name that they prefer so that they don't besmirch the Verizon Wireless brand, may not place an antenna equipment without the consent of immediate adjoining property owners or the authority's approval. If you go to the next page, you'll see the second to last paragraph where the authority also directed the wireless service providers request consultation prior to filing the application. This letter constitutes Selco's request for consultation. We'd be pleased to meet or otherwise confer with you, discuss the project in any question. In my view, this particular letter does not satisfy 170249 because we specifically asked that the wireless carrier designate a non-attorney contact. But in any event, that is your sign, that paragraph, that it's time to request that consultation. The next page. The next page shows the people who got notice. And this is important to look at because if you look at the, you'll see the blocks for the address, the property owners of record, according to the town land records. And you'll see this is a Cheshire utility pole located in Cheshire, yet you'll see that there's no local property owner here. That is a real key to municipalities, that they need to step in and really check out where this proposed small cell facility is going to be sited, because the chances are it's not a local property owner. Their interest is going to be slim to none. All right, next page is just a map. It's pretty much, I don't know if you can see it on your screen, but they talk about the existing utility poles, and they show the various, they show the power source, they show the pole number that's going to be replaced. And then this, the next page is one I think is very important. Probably should have circled it for you, but there is a photograph on the right side of the pole in the street where it's located. But then if you look at the diagram shows the proposal. And in this case, if you look about maybe 60% up the way of the pole diagram, you'll see an arrow, but on the right hand there's a language says the top of the existing utility pole and the elevation there. And you'll see that is 24 feet. So that's the existing pole. And then you move further up to the top of the pole, and you'll see just below the canister, which is a small cell canister that will be installed, you'll see the top of the replacement utility pole, and that is 34 feet elevation. So this is a pole that will be increased in height 10 feet. That's a significant increase. And that, again, that is an issue that the facility should be, that the municipality should be very interested in. The only thing I want to show you on this particular slide, again, this is just diagrams, but in diagram number 5 on the bottom left-hand corner, you'll see the canister and dimensions of that. What Verizon, what the town of Cheshire did in this particular case is they participated by having us send in a letter on their behalf saying we want the canister painted the same color as the utility pole so that it would not stand out, particularly given the increase in height of the pole. I thought that the municipality should challenge that increase, but they decided that they would just limit their comments to the color of the canister. And Verizon, we discussed that with Verizon. They agreed to it, and we memorialized that in writing to PURA, and PURA put that in its final decision. The next slide just shows what's called the cumulative power density, and again, that's there's no jurisdiction, so they're only going to show you RF emissions and power density issues that are below the acceptable standards, the maximum acceptable standards. So, in any event, that's just a quick rundown. So,
we're just going to move into some unresolved issues that are outstanding that CCM is still very sensitive to, with regard to what was kind of left out of the decision and what was left out of any consideration. Although CCM, during our time at in the legislature and with the help of Senator Schlossberg and members of the West Haven delegation, we did bring these to the attention of the legislature and thereby PURA during that process. One in particular is that these small cells will start, like I said earlier, to proliferate at a rapid rate as soon as multiple wireless carriers come into the state. This is an issue that I think that the statewide plan would have resolved, whereby it would have created more of a process by which these small cells would be sited, and perhaps more of an opportunity to require cooperation between providers, limiting the number of actual facilities. Also, as mentioned before, there's also the outstanding idea that PURA is not the statutory authority over these small cell sightings. We are still of the mind that the Siting Council would be the better place for these type of proceedings. There's also the idea that these poles are being replaced prematurely, and as Bert mentioned, the height of these poles is increasing, and thus the aesthetics of the community will decrease, in our opinion, and thus the issues of property values and the effect that those pole increases will have on property values and property taxes is a huge concern for us. And finally, the idea that mentioned before, that before the Siting Council, these type of companies, such as Verizon and their company Cellco, are getting a free ride through PURA with regard to the applications that they're filing, and thus you'll see the number of applications that are being filed and taking advantage of that free ride, in our opinion, is just really unfair and increasing the proliferation of these facilities. Just quickly to go through some takeaways and some recommendations moving forward. We are just recommending that you, as a municipality, and then also the attorneys within those municipalities, whether they be in-house attorneys or contracted attorneys, to remain vigilant on all of these applications. As Bert mentioned, these residents are getting a notice, and certainly in most cases, these residents really have no idea what they're consenting to. And so it's really important that on the part of the municipality and the CEO and whomever within the town is appointed to handle these types of applications, that the residents also be informed that they are providing their consent, and without such consent, these types of facilities are not to be placed on the polls. And kind of in moving in line with that same recommendation, we recommend that you provide a point person for these applications. And we say that because the number of applications on a daily basis, I mean, through my email, I get, like Bert said, like 10 of them, and a point person within that town is really a good idea, so that there's nothing that's missed. And then also someone that the residents can talk to directly, who would have seen the notice and has some recognition of what's happening. We've talked about the height. Let's see, maintain. And then number 4, whether or not the municipality has any specific concerns about the proposed site, it's really important that we send, or the municipality sends, a letter to PURA, just, creating a position for the town, just so that they know that we are watching and listening, and so that these companies are not our voice before the regulatory authority.
Yeah, and just in that regard, Donna, so many of these applications, Verizon's attorney is making formal representations on the public record, and this is available to anybody who go on the PURA website, that you, the municipality, have consented to this. And that may not, you may have said you have no objection, but they, I think you want to make sure that the record is clear as to what your own position is.
And then on the next slide, we'd also just, making sure that when, like I said, when you do get these applications, please just consult with an attorney. It's important that, you are represented in the legal way, and then making sure that when you're reviewing these applications, and in particular when there are residents who have come to the table saying that they have concerns, just to make sure to voice those concerns to not only the community, but also to your legislative delegation. It's important, as we saw in the West Haven case, that engaging your legislators and senators in Hartford is so important, because with the help of Senator Schlossberg, we were able to put some significant pressures on PURA, which ultimately helped us in what was the final decision before the PURA. And also just feel free to reach out to me at CCM, and certainly if you're a member of COST, to Betsy Guerra at COST, who is also involved, just to make sure that we are always there to help you and guide you in whatever questions you may have with regard to these applications. And then finally, if a utility pole is being replaced, to make sure to check with the utility doing the change out to ensure that the pole replacement is being performed for the small cell installation prior to, making sure that it's not happening prior to any PURA approval, because that's very important. We don't want these telecos to sort of walk all over us without us paying any attention. Also, just, of course, for all of you municipal local officials on the line, you know that safety for your residents is of utmost importance, and we know that that is the case for you. So just making sure that as we're reviewing these applications, and whoever the point person is, just making sure that these are being placed safely and not in a way that could create hazard for the residents within the town. Like the case in West Haven, that particular pole that the community had raised concerns around was a pole that had been part of a number of accidents prior to the installation, and it really helped knowing that, because it created an argument before the PURA for their case. There's also no need to update or revise any of your municipal ordinances or zoning codes for the small cell facilities, because PURA will not consider them and rely solely on statutory jurisdiction over the utility poles. Also, I just wanted to add, in addition to some of these takeaways, just my own. In West Haven, they were very successful because they had a community that got together and expressed these concerns. Legislators are always heightenedly aware of issues when a community rises together and creates media attention, and also just comes together to support each other. And I think the local officials really can stand to get that help and that attention, and it really worked well for the West Haven case. And I would recommend that if you do speak to your residents about these issues, just to make sure that they know that working together and working in numbers is probably the best way to do this. And then, of course, as I mentioned, just making sure that residents are informed about the consent that they're providing for these installations. I think that's it for us. I think we're going to look at the questions now. So thank you for your patience and walking us through this presentation. What's the first one? I can't see it.
Where do we locate on the right?
Yeah.
Where's this question?
I think the where do we
can't really see.
Slides.
Okay.
I'm going to keep clicking.
Okay, where do we locate?
Screenshots aside. Yeah.
Oh, shoot. Okay.
Okay, at this point, I don't think we have any questions. So we are going to send out the PowerPoint to the registrants. If the attorneys who are listening want a letter indicating your participation on this, I think we have a listing of the names of the people who signed up. Just shoot me an email and we'll get a letter out for you. I'm not going to opine as to whether you are, this is CLE eligible, but in my opinion, on the record it is. So just send us a letter. And again, we want to thank you and good luck, and make sure that you contact CCM. Feel free to contact me if you have any questions or need any further advice on these issues.
Great. Thank you so much for joining.